Okay, picture this. You've got this really famous Italian fashion brand, right? Think made in Italy, classic style.
Uh-huh.
And suddenly, their authentic stuff gets seized in South Africa. Why? Because someone says it's counterfeit.
Wow. Even though it's the real deal from Italy.
Exactly. And the kicker, their original trademarks in South Africa they'd lapsed. Someone else swooped in and registered the name legally.
Okay, that sounds like a legal thriller plot. And straight away, that tells you something pretty important, doesn't it?
Definitely. Even these huge global brands, they can lose their protection in one country just by, missing a renewal fee payment.
It's a wild scenario. Yeah, that's exactly what we're diving into today here on The Deep Dive. We're unpacking a recent South African Supreme Court of Appeal judgment that tackles exactly these kinds of issues.
Yeah, our mission today is really to slice through the legalese, know, and try to get our heads around this pretty complex fight.
Mm-hmm.
We want to understand why the judges themselves couldn't agree, and maybe more importantly, what this all means for anyone dealing with trademarks, brand authenticity, global business, really.
And we should say, we're drawing this all directly from the official court judgment. So, it's straight from the horse's mouth, so to speak.
Okay, so let's paint the picture. The brand at the heart of this is Enrico Coveri.
Right. Named after the Italian fashion designer, Mr. Enrico Coveri. He was pretty big in the 90s, global sales, that whole made in Italy vibe across clothes, jeans, everything.
And after he passed away in 1990, his sister, Miss Silvana Coveri, she kept the business going. Enrico Coveri SRL, the Italian company.
But here's where things took a turn, that really crucial misstep you mentioned.
Yeah, this is key. So the Enrico Coveri trademark, it was registered properly in South Africa back in the mid to late 80s.
Okay.
But then they were removed from the register in 98, 99, and 2006. Why? Non-payment of renewal fees. Mrs. Coveri apparently attributed this to the difficult period after her brother's death. But whatever the reason, this admin error, basically forgetting to pay the bills, it just swung the door wide open.
And walking through that door was Mr. Yossi Barel.
Right.
He then went and registered the Enrico Coveri trademark in his name in South Africa. Across several classes, including footwear, registered in 2007 and 2013.
How did he even land on that name?
Well, his story is pretty interesting, too. He says back in 2005, he was in a factory in China, and someone there suggested some names for his new clothing and footwear line. Enrico Coveri was on the list. Barel asked about it and was apparently told, it's an Italian brand, but it kind of gone off the radar since the 80s.
Okay, so he liked the sound of it, the Italian connection.
Yeah, he adopted it. And then he launched his own Enrico Coveri line in South Africa around 2005, 2006, with goods made in China and Turkey.
So now you've got Barel, the legal trademark owner in South Africa. But wait, there's another player, right, with their own history with the brand.
Exactly. Popular Trading CC. They're a South African company, importing and distributing footwear.
And their connection?
Well, it's layered. From about 1999 to 2009, they were importing Enrico Coveri footwear from China. And they actually admitted this stuff was, quote, non-authentic.
Ah, okay, so copies, basically.
Seems like it. But then, and this is a really important shift, from 2010 onwards, Popular Trading changed tack. They started sourcing authentic Enrico Coveri footwear.
Authentic?
Directly from the licensed manufacturers of the original Italian company, Enrico Coveri SRL. They were adamant about this, saying their goods were, genuine, of legitimate or undisputed origin.
Okay, so you've got Barel with the local trademark and Popular Trading bringing in what they say are the real Italian goods. That sounds like a recipe for, well, exactly what happened.
Absolutely. A head-on collision was almost inevitable. In December 2021, Mr. Barel filed a complaint under South Africa's Counterfeit Goods Act.
The CGA?
Right. He said Popular Trading wasn't listening to his demands to stop using his trademark. So a magistrate then granted a search warrant.
Which lets the authorities go in and seize goods they suspect are counterfeit.
Correct. To search Popular Trading's warehouse for these purported counterfeit goods.
But Popular Trading didn't just roll over.
Not at all. On February 7th, 2022, they filed an urgent application in the High Court. They wanted two things: get that warrant thrown out, and crucially, get a legal declaration that the goods were not counterfeit under the Act.
But the seizure still went ahead.
Yeah, despite the court challenge, the warrant was executed just a few days later, February 11th and 14th. They seized all the footwear marked Enrico Coveri.
So what did the High Court say initially?
Initially, the High Court actually sided with Popular Trading.
Oh, interesting.
Yeah, they set aside the warrant and declared the goods not counterfeit. The judge felt Barel hadn't disclosed everything he should have and hadn't really shown a prima facie case.
Prima facie, meaning like on the face of it, not enough initial proof.
Exactly. Not enough initial proof that counterfeiting was actually happening.
So High Court says, nope, not counterfeits. But Barel appealed.
He did. He got special leave to take it up to the Supreme Court of Appeal. And this really is where the legal heart of the matter gets dissected.
Okay.
The absolute core issue, the crisp issue, as the appeal court called it, was simply, are these seized goods from Popular Trading counterfeit goods under the Counterfeit Goods Act? And importantly, the burden of proof was on Popular Trading to show they were not.
So Barel's argument was pretty straightforward from his perspective, I guess.
You could say that. He argued, look, I own the registered trademark in South Africa. Popular Trading is using the identical mark on shoes without my permission. That's trademark infringement under the Trademarks Act. And therefore, he argued, that automatically means it's counterfeiting under the Counterfeit Goods Act.
Okay, simple enough. But Popular Trading pushed back hard on that.
They did. They argued that counterfeiting isn't just trademark infringement. It needs something more.
Something more, like what?
They pointed to another case, the Puma case, which defined to counterfeit as like making an imitation to deceive,
right,
or making a copy. They insisted that this something more is fraud, an intent to fool the public.
And their argument was, we aren't trying to fool anyone. These are the real Italian goods.
Precisely. They said, we have zero intent to deceive because our goods are authentic from the original source.
And have the courts actually made that distinction before between simple infringement and like deliberate counterfeiting?
Yes, they have. There's another case, Canak, where the court said counterfeiting involves deliberate and fraudulent infringement. And it specifically mentioned that counterfeit cases usually involve someone trying to reproduce and substitute the goods themselves, not just slapping on the trademark.
So it's about passing off your product as the trademark owner's product, not just using the name.
That's a key distinction courts have made. And this leads us right into the definition in the Counterfeit Goods Act itself, Section 1B.
Okay, what does the act actually say?
It defines counterfeiting as basically making or putting a mark on goods without the owner's authority. Or using a colorable imitation, meaning something very similar, designed to mislead, so that the goods are calculated to be confused with or to be taken as being the protected goods of the owner.
Calculated to be confused.
And protected goods is broad. It can even mean stuff the trademark owner might make, not just stuff they already sell. So it's not just about cloning. But that phrase, calculated to be confused.
That sounds like the exact point everything turned on.
It absolutely was. And here's where it gets really fascinating. The Supreme Court of Appeal judges couldn't agree on what calculated to be confused actually means in this context. They were divided.
Wow, the highest court was split. Okay, so what were the two different takes?
Well, the majority view, written by Justice Hughes, ended up siding with Mr. Barel. They won the appeal.
Okay, what was their logic?
They said, look, the mark on Popular Trading shoes is basically identical to Barel's registered mark. They did acknowledge that maybe, initially, Popular Trading didn't intend to cause confusion when they first started importing the authentic goods.
Right.
But, crucially, once Popular Trading knew about Mr. Barel's registered trademark, their continued deliberate use of that mark was, in the majority's view, calculated to confuse the buying public.
Ah, so even if they didn't start out intending to confuse, by continuing after they knew Barel owned the local rights, that became an intent to confuse.
That's exactly the majority's reasoning. They felt it created the impression that Popular Trading's goods were linked to Barel's registered trademark. So they concluded this was deliberate and fraudulent infringement, and therefore counterfeiting under the Act.
Okay, they basically said counterfeiting is like automatically trademark infringement, but even more serious.
Pretty much. They said counterfeiting, a fortiori meaning all the more so, includes trademark infringement.
Right, so that was the majority. What about the judges who disagreed? The minority?
The minority view, from Justice Blum, came to the complete opposite conclusion. They would have dismissed Barel's appeal.
And their argument.
They focused laser-like on that word calculated. They argued calculated must mean planned, designed, or intended.
So for them, you needed actual intent.
Yeah.
Like mens rea, a guilty mind. Specifically, dolus intent to deceive.
Exactly. The minority said, without proof of that specific intent to deceive, you simply cannot have counterfeiting. Mere infringement isn't enough.
And how did the authenticity argument play into their view?
It was central. Justice Blum stressed that Popular Trading was importing authentic Enrico Coveri shoes from the original Italian company's licensees. He even asked rhetorically in the judgment,
Yeah.
why would the importer and distributor of authentic footwear intend his footwear to be confused with or to be taken as being the footwear manufactured by a company other than the company that manufactures the authentic footwear?
Good question. Basically, why pretend your genuine Ferrari is a kit car?
Kind of, yeah. The minority felt there was no evidence Popular Trading ever intended its shoes to be confused with Barel's locally made ones. They reiterated, counterfeiting needs more than just trademark infringement. The fact that the goods were genuine mattered hugely to them.
So two completely different interpretations of calculated to confuse leading to opposite results, but the majority won out?
Correct. In the end, the Supreme Court of Appeal upheld Mr. Barel's appeal. The High Court's decision was overturned. Popular Trading's application to declare the goods non-counterfeit was discussed.
Meaning the seized goods were officially deemed counterfeit, even though they came from the original brand's legitimate supply chain.
That was the final legal outcome. Yeah.
Wow. Okay, so let's unpack this. What does this ruling really mean for, for businesses, for consumers, for anyone navigating this stuff?
Well, first off, it just screams complexity, doesn't it?
Yeah.
Intellectual property law can lead to some really counterintuitive results. You'd think authentic means safe, but clearly, local trademark law can override that.
Yeah, that's a huge takeaway. Relying just on a brand's global history or origin, that's risky if someone else holds the legal trademark rights in a specific country like South Africa. History isn't always enough.
Absolutely. And it really highlights that razor-thin line between parallel importing, bringing in genuine goods legally bought elsewhere, and those same goods being labeled counterfeit if they clash with local trademark rights.
Especially if a court decides your continued selling, even of genuine goods, shows an intent to confuse once you know about the local registration.
Precisely. That finding of later intent by the majority is critical here. Businesses need to be incredibly careful about checking local IP rights before importing, even if the goods are genuine at source.
And for us, just as people buying things, what's the message?
It's a bit mind-bending, but it shows that authentic from the original maker doesn't automatically mean legal to sell everywhere. If it infringes a local trademark, and especially if a court perceives an intent to confuse the local market, well, it could still be deemed counterfeit in that specific place. Authenticity isn't always legally absolute.
Okay, so this whole deep dive really shows how tangled things get with intent, legal history, and who owns what where.
Definitely. And it leaves us with a really interesting question to chew on, I think.
Yeah.
In this global marketplace we live in, when does the authentic origin of a product just fundamentally clash with local IP rights?
Yeah.
And, who ends up carrying the risk and the burden of figuring out that complex legal maze?